that IDAC's mandate, insofar as Section 7, subsection 1A, is concerned, is to investigate serious corruption or serious commercial or serious financial criminal cases, high-profile corruption or serious commercial or serious financial criminal cases, complex corruption or serious commercial or serious financial criminal cases. In other words, the case may be serious or high-profile or complex. This may be an incorrect understanding, given the debate at the Commission, but this is how I was made to understand IDAC's mandate in terms of Section 7. This may be one of those matters where the Commission's recommendations may assist our office. I will not deal with the structure or the process of how a referral to IDAC is supposed to be handled. Mr. Sissoko, the head of investigations and operations, is best placed to do this. I will deal with the Section 27 referrals based on my personal experience and understanding of the SOP. Case Selection Criteria Directive issued and signed by Advocate Johnson and Mr. Sissoko in October 2024 and in August 2022, respectively.
Okay, the next topic is a referral to IDAC.
In explaining the Section 27 referral process, I must set out the following. At the time of the Adams referral, the bulk of IDAC's cases were either existing cases from other units, such as the Specialized Commercial Crime Unit, or cases emanating from the reports of commissions of inquiries, such as the State Capture Commission or the Nugent Commission. I am only aware of one other 27 referral since I joined IDAC in March 2023. This related to a matter involving a high-profile individual. I have provided some documents relating to this matter in the Commission to demonstrate the difference between how Section 27 referral was dealt, this Section 27 referral was dealt with, and how the Crime Intelligence Section 27 referral was dealt with. This was and still is a standard operating procedure referred to as the IDAC Operation Manual, issued and signed by Advocate Johnson and Mr. Matthew Sissoko, the head of investigation, on the 16th of October 2024, which I have also provided.
Miss, just raise your voice again and...
Sorry.
Yes.
If I may just have a bit of water. There was and still is a standard operating procedure referred to as the IDAC Operation Manual, issued and signed by Advocate Johnson and Mr. Matthew Sissoko, the head of investigations, on the 16th of October 2024, which I have also provided to the Commission. In addition to the SOPs, Advocate Johnson would from time to time issue additional directives. Prior to the issuing of the SOPs, Advocate Johnson and Mr. Sissoko also issued a case selection criteria manual of sorts, which set out in detail the process to be followed in selecting cases to be investigated by IDAC. I have also provided this document. IDAC operates on the principle of prosecution-led investigations, which means that every matter is led by a senior prosecutor at the level of Deputy Director of Public Prosecution, a DDPP, working within a multidisciplinary team of prosecutors, criminal investigators, financial investigators, and data analysts. May I just, on a side note, prosecution-led investigations, if correctly done, is a brilliant method. But as it stands, it is left open to manipulation of targets. It is so easy at this point of where we are as IDAC to manipulate the statements, who the suspects are, how the investigation is to proceed, who witnesses will be, what these witnesses will say, how they will say it, what evidence is included, what evidence is not included. And it has, as I will later show, been manipulated by and used.
Must we understand that to mean this is not necessarily about the structure, it's about personalities, or what makes it easy for this to happen?
There's no checks and balances.
You need to raise your voice.
Sorry. There's no checks and balances. Prosecution led with proper checks and balances. For the purpose for which IDAC was established, would excel in recovering money for Kara, successful prosecutions for corruption. As it stands, and I'm not saying all the cases, I mean, we've got some very good prosecutors, and we've got some very good, honest working people in IDAC. My reason for bringing this is, because there's no checks and balances, we are where we are today. I'm giving evidence today because of the manipulation of Section 20 and the prosecution led.
Do you, but only if you've applied your mind to it and are able to answer, do you have in mind the sort of checks and balances that would address the shortcomings?
The SOPs speak to a panel that includes investigation, prosecution, and other multidisciplinaries that are housed within IDAC. And that panel was supposed to make decisions collectively using different knowledge, skill sets. It's not applied. The checks and balances are who checks that? Where's the authority that checks that we are complying?
There's that old Latin saying, I will not say it in Latin, who will guard the guards?
Yes.
It sounds like that's basically what you are saying.
Yes, that is what I am saying, because if you look at the structure of a general prosecution, OCC is prosecution guided. There are so many checks and balances in place to prevent this very thing that we are talking about today. Am I too soft? Sorry. This very thing that we are talking about today is prevented in that unit because there's checks and balances.
And so just to be sure that I understand, are you saying let me loosely call it the broader NPA, the NPA outside of IDAC, are you saying these checks and balances do exist there? Is that what you are saying? Or
correct.
All right.
Can I just ask slightly different, the same question? Are you saying there are no checks and balances because people do not adhere to the operations manual which prescribes or which sets out that there will be a team which is constituted in the way that you have described? Is that where the comment comes from? There's no adherence to that? And if the answer is yes, it seems to me then you're saying if we adhered, we do have something that's supposed to guide us, we just don't comply with it. And if we complied with it and adhered to it, then what is happening now would not happen because we do have written down checks and balances. I'm just trying to understand whether there's no provision, adequate provision, or there is provision, it's just not complied with.
If I may if I'm a practical situation of within the office, So when you do the investigation plan and the taskings and the deputy director is in charge of, the former head of IDAC would, so if I had a problem with Advocate Ncube, I could go and gossip. I could really just, our office was run on gossip. You would be called into the office on gossip. But I could go and gossip about Advocate Ncube and say, Advocate Ncube doesn't know what she's doing, she's confusing the processes, and then the next meeting, Advocate Johnson is at the meeting, and what I said is golden, but the correct way that Advocate Ncube is asking for is out the door. So, in as much as we've got a structural basis, the head constantly would interfere and deviate from that.
It's not a question, it sounds from what you're saying, and please just clarify for me, it sounds like it's not a question of something must still be invented that will provide the checks and balances, that would obviate what you're describing now, but rather you do have the tool on paper. If only we all complied with it and strictly, then this concern or this complaint and its consequence would not happen.
Correct. Also, you must understand, until March 2026, none of this could be reported, because who do we report it to? Now that Advocate Mutibi is there, we are a little bit braver to come forward about these things that we were being instructed to do.
Does I don't know much about it other than what has been reported in the media. You know better and much more about it. Does the office, the existence of the office and now the appointment of the office of the IDAC judge, I'm going to call him that, in its mandate, and its written mandate, I'm not talking about informalities, I'm talking about formal mandate. Does that address what you're raising? If there is concern about matters that relate to the ID, or for that matter, even the NDPP, because there's now this great friendship between the ID and NDPP. Does the mandate of the judge include that you can escalate matters that you're concerned about? You could escalate them to that office?
To an extent.
Okay.
To an extent. But it will become clearer
As you can.
as I go on.
Okay, thank you.
Ms. Ramsamy, I don't want to keep reminding you to raise your voice.
I'm sorry. I'm sorry.
Can we then go to the next topic, the investigation process in respect of a Section 27 referral?
The investigation process is supposed to follow a sequence as set out in the SOPs in the Case Selection Criteria Directive. This is how the process is supposed to work, but even in other Section 27 referral, the other Section 27 referral I deal with later, there was no strict compliance with this process. Once again, this is how the process ought to be implemented, but it is not always done this way. Having said that, in my view, the failure to adhere strictly to the SOP does not mean that the process is irregular. As long as the process complies in substance, it would not be irregular. I will explain later when I deal with my first Section 27 referral. Since joining IDAC, I have been designated to a number of multidisciplinary investigations and prosecution project teams dealing with serious, high-profile and complex corruption, commercial and financial crime matters. In that capacity, my functions have included assessing a Section 27 compliance with the IDAC mandate, formulating and executing the prosecution strategy, working with investigators from the inception of an investigation, and guiding matters from intake through to enrollment. Given that my experience of dealing with the Section 27 referral, other than the crime intelligence referral, is limited to only one prior referral, it would be easier for me to explain, with reference to my prior experience, how a Section 27 referral ought to be dealt with in practice. The irregularities of the crime intelligence referral will become abundantly clear to the Commission. In July 2023, I received a meeting invite from Advocate Johnson. The other attendees were another state advocate, Mr. Dylan Perumal, Chief Investigator, Mr., if that may be corrected, it's Mr. Tamane Benang. Investigator, Mr. Mansa Rapesu, Senior Investigator, and Mr. Sissoko, Head of Investigations. At the meeting, Advocate Johnson stated that she had received a Section 27 referral and that had held a consultation with the deponent and the deponent's legal representative. Advocate Johnson briefed us on the averments and then instructed the team that no one was to know that we were handling the matter, owing to the sensitivity of the information and of the implicated person or persons. Advocate Johnson then instructed the prosecutors as follows, which I might add are consistent with the case selection criteria and SOP. My underlining of certain portions of the subparagraphs that follow is deliberate for the reason that will become clear later. We were to make copies of the statement, the prosecutor and myself, that she had handed to us and return the original to her office. The prosecutors were to interrogate the affidavit and decide whether it fell within the mandate of ID. Once the prosecutors had reached consensus, we were to draft a certificate of mandate. If our assessment was that the case did not fall within the IDAC's mandate, we were to compile a comprehensive memorandum detailing this finding. Once the certificate of mandate was signed, the prosecutors were to attend to drafting the application of authorization of a Section 2813 investigation. And once authorization was signed, we were to consult with the investigators and draft an investigation plan. Should the investigation yield evidence of criminality, we had to motivate for a Section 28.1 authorization. This motivation had to be accompanied by an evidential report prepared by the prosecutors, which is a full and detailed summary of the facts and evidence in each statement obtained. And should the investigation show that no criminality could be proven or that there was no prima facie case, the prosecutors would prepare a detailed memorandum setting out a summary of each statement and a detailed submission as to why there was no prima facie case, as I will illustrate later in the statement. This process was followed in this regard. I refer the Commission to the following documents, which I ask not to be displayed, or if displayed, to be redacted.
At this point, Commissioners, if we 93 of file 10, this can be displayed because it makes no reference to the matter itself, but it is an example of the consideration of mandate that Ms. Ramsamy is testifying to. So that's page 93 of file 10. Do you have it?
Thank you.
This will then correspond with your paragraph 23.1 of your statement.
Correct.
Okay, so maybe if you can just take us through the document.
Myself and the other advocate that had been allocated to the matter And I might add at this point, when we were given this 27 referral, we were given a week to interrogate the evidence contained in the affidavit referral. We then drafted this indicating that we had found sufficient evidence that it did fall within the IDAC mandate, not only under high-profile individual, but also serious corruption.
Okay, thank you. So we can go back to your statement 23.1.
Maybe before you do that, the page 93 is quite scanty. Is that all you say? You have an introduction. I'm not asking you to speak to that specific referral. I just want to get a sense of what information, in fact, gets covered in this kind of document. What do you discuss?
There was a verbal briefing about the allegations, and then once we received we did a comprehensive application for 2830. When I say comprehensive, we also included a 19-page summary of the evidence that was contained to confirm our mandate and our application for the 2830. And
so you set out what the matter is about,
correct.
What you have found, what you have to inform a decision on the recommendation that you're making.
correct.
Okay.
And so this would be the first page. This is our recommendation having regard to what had been provided to us, and then you include your summary, the 19-pager.
Correct.
Okay.
I unfortunately cannot give that to the commission.
No, I understand. I just wanted to have a sense of the decision maker, because this on its own is not very helpful at page 93. It doesn't tell you what the decision maker has in front of them to exercise the discretion whether to accept or not accept the recommendation. Thank you.
And then just still on that document, we have, at B, it says recommendation. This matter falls within the mandate. That's your recommendation with the other prosecutor. And it then goes to Mr. Sesoko and Advocate Johnson.
Correct.
For their recommendation.
Correct.
Or approval.
So they
He recommends and she must approve.
correct. It's so that it's what I spoke of the previous way we dealt with checks and balances.
Okay. And then at 23.2 of your statement, you deal with the application for authorization for Section 2813. So that happens after Advocate Johnson confirms that she approves that it falls within the mandate. After you submit this document, the consideration memo of mandate and the summary, and then she would ask you, who makes the decision that there must be an application for 2813?
After the report and the certificate, we would then receive an email or a WhatsApp from the PA indicating that please come and collect your certificate, and at that point we'd be informed, proceed with drafting a 2813. It was not a matter of us just bombarding them with the applications. We had to get permission for each step.
Okay, let's try and finish this section before T. Above 24.
Thereafter, a meeting with the investigators took place and an investigation plan was drafted. This is referred to as a prosecutorial plan. Once the investigation was completed, I drafted what is referred to as an evidential report. This report provides a detailed summary of the evidence contained in each statement obtained, how the individual statements or collective evidence is linked to the elements of the offense. At some point, the state advocate was removed by Advocate Johnson and a deputy director was allocated to the matter. We drafted and submitted a request for a Section 28(1) to be approved, and upon approval of the request, the Section 28(1) was submitted and signed by Advocate Johnson. The process of registering a docket and enrollment then followed.
Thank you, Chair. Would this be a convenient time to take the T adjournment?